thank you for joining us for today's Housing Rights panel. We are very excited to have presenters from the Commonwealth's Attorney General's Office, as well as from the city's Human Rights Commission. Our presenters today from the Office of Attorney General Maura Healey are Yarlenis Villeman, the Outreach Director, and Chanel Neves McCain, an Assistant Attorney General. They will be presenting on landlord and tenants' rights, as well as discrimination in housing. Presenting for the Human Rights Commission is Carolina Almonte, the Attorney Investigator for the Commission. Carolina will also be presenting on housing discrimination and the Commission's complaint and investigation process. After the presentations, we will have time for question and answers, and we will be monitoring those Q&As through the Q&A feature on Zoom, which Crystal will talk about in just a few minutes. Today's webinar is part of the Housed in Cambridge Information to Open Doors campaign. Housed in Cambridge is a multi-department outreach, education, and information effort organized by the City Manager's Office of the Housing Liaison, the Community Development Department, the Human Rights Commission, and the Department of Human Service Programs Multi-Service Center. The goal of Housed in Cambridge is to centralize housing resources and to make it easier for residents to access the information that they need, no matter what their housing-related issue may be. Today's webinar is the latest in a series of information sessions. Other sessions have included a variety of topics like affordable housing, understanding options, opportunities, and pathways, fair housing and basic tenant rights, resources for first-time buyers, eviction prevention, and subsidized housing. All of these sessions have been recorded and are available on the city's YouTube channel as part of the city's virtual library of housing resources. So if you've missed a previous session, you can access the recording on that YouTube channel. Another component of the Housed in Cambridge program is a comprehensive online guide to help residents learn more about Cambridge housing providers and the resources that they offer. That interactive guide is available at cambridgema.gov/housing guide. So please share information about the Housed in Cambridge initiative with family, friends, and colleagues. And please reach out to us if you have ideas about information or resources you would like to see included, or if you have any questions about the Housed in Cambridge campaign.
Good afternoon, and thank you so much, Jennifer, for the introduction. I'm going to have my colleague, Chanel, display the PowerPoint so we can see the presentation for today. My name is Yarlenis Villeman. I'm the Outreach Director in the Community Engagement Division, and I'm here with Chanel Neves McCain, who is our Assistant Attorney General in our Civil Rights Division. Thank you again to the Human Rights Commission for the invitation today. We're truly grateful to be here today to present on landlord and tenant rights. So before we begin on the topics of landlord and tenant rights, I just want to give a little overview of our office and how we can serve each and every one of you. So first and foremost, the Attorney General. What do we do in our office? On the next coming slides, you're going to see a picture of our Attorney General, Maura Healey, who is the Chief Lawyer and Law Enforcement Officer of the Commonwealth. Well, before then, I'm just going to give also a little overview about what we're going to be covering in the next coming slides throughout the presentation. So first and foremost, we're going to give an overview about the landlord and tenant rights and obligation, the eviction process and tenant assistance, as well as housing discrimination and prohibited conduct related to source of income discrimination and discrimination based on disability. So I will mostly be covering the landlord and tenant rights and obligation and the eviction process and tenant assistance, and then I will give the platform to my colleague, Chanel. So what are the obligations of a landlord and a tenant? First and foremost, the obligation of a tenant is to pay the rent. And we know for sure that due to the pandemic, there has been many tenants who have been affected with loss of jobs and have financial hardship. So I'm going to give you more resources in the next slides of rental assistance programs that are available for you if you need help paying your rent. But usually the tenant also has to follow the rules agreed upon with the landlord and accept the responsibility for the damages beyond the normal guarantee. And I will talk a little bit more about that phrase beyond the normal guarantee when we talk about the security deposit. But the landlord has to do two major things: provide an apartment that is safe, clean, and in compliance with the sanitary code. And I'll talk a little bit about the process of the sanitary code. And they have to live up to the promises made in the lease and rental agreement. Next slide. So first and foremost, the sanitary code. There are a few processes you must know if there is a type of violation in the sanitary code. Most importantly, the landlord has to apply with the sanitary code that has to require a place that is habitable, comfortable, and clean enough for a person to live safely. So they have to provide that apartment that is safe enough. Now, if there is a violation with the sanitary code that the landlord has to face an issue that is part of the sanitary code, then you as a tenant will have to, first and foremost, we do advise you to contact your landlord, let your landlord know about the violation. Now, if they haven't fixed the issue, then you can either request an inspector to inspect the place from your city, and the inspector from your city will go to that apartment place to check out. And then if there is still violation in the in the unit that you live in, then the inspector will fine the landlord until the issue is fixed. The other step you as a tenant can do is, if the landlord continue to fails to fix that problem, is that you can withhold portion of the rent or move out. Now, as we are representing the Attorney General office, by law, we cannot give any legal advice. So even today, when you have questions, try to ask questions that are general, because if you have questions that are legal based, we will refer you to a legal aid agency or private attorney that can assist you, even when you call our office. So I do advise you, if you're trying to take step number 3, to withhold portion of your rent or move out, I do advise you to call our office so we can give you a referral to an attorney, to talk to an attorney first before deciding to withhold portion of your rent. The next slide, please. So if you're facing with an eviction, what is the process? If there is a process, just because you receive a letter from your landlord does not mean that you have to be evicted from your unit or your household apartment that you live in. And that letter will be a notice to quit. On the next slide, please. You will see how the eviction process starts. So usually the landlord must give a 14-day or 30 days notice to quit to the tenant. This particular letter, a lot of times tenants do assume that because they received that letter, you have to move out of the property. And no, you have to get a judge order from the judge. There is the housing court hearing that you will have to attend, and the judge will let you know if you have to move out of the property. So after you receive that notice to quit letter, then the landlord has to start a filing in the housing court called a civil action in court. Then the landlord must get a judgment from the court with the date that the tenants must live by, but it will be the judge that will decide that. And it's important that as the tenant, you do attend the hearing, because you can raise a defense to the eviction of that particular case. And it is very important for you to attend that hearing if you do have one. We have been noticing a lot of time because of the pandemic, there have been online hearing, and there had been a lot of technological issue of people don't having access to technology. So we did create a program to give access. So it is important for you to know that if the judge at that moment decide that you have to leave the property, then a sheriff from the court will go with you to get your belongings. It is also important for you to know that if you are in the process that you have applied for any of the rental assistance program, for instance, RAFT or ARAP, and I'll talk a little bit about those programs. There has been a hold. They can hold the hearing and don't make a final decision there because you still have your application pending and it hasn't been approved yet. So there are some situations there where the pandemic has changed the decision of you continue with the hearing or not. And it is important for you to let your attorney, if you have an attorney, and the judge know at that moment that you still haven't received any approval from RAFT or ARAP if you have applied for any of those rental, because they will hold the hearing to give you another new date. Next slide, please. It is also important for you to know that before I talk about the access to eviction programs grants, and there have been 4 locations that we have collaborated with. So if you are in need of obtaining any type of technology because you have a hearing that is online due to an eviction process, it is important for you to contact immediately our office, and we can advise you what 4 agencies we're working with, or you can also talk with the Human Rights Commission and see any resources that they have. But we have been collaborating with 4 different agencies throughout Lynn, Everett, Lawrence, and Brockton, because we have seen very high cases of eviction, and we created that eviction programs grant. But we also have created an AGO eviction help request form, where if you are in need of getting information about rental assistance program, or your landlord tries to make you leave your home without a court order, you should report it immediately to our office, especially in our Civil Rights Division. I will give you that number directly. Or you can also complete the form that is listed on your screen right now at www.mass.gov/form/eviction help request. So one of our attorneys can send you the information and help you with the issue that you're having at the moment. So I will give the platform right now to my colleague, Chanel, to talk a little bit about discrimination in housing.
Thanks, Jarlenise, and thank you to the Cambridge Human Rights Commission for inviting us here today. As Jarlenise mentioned, we're going to talk about some of the resources, income and housing resources that are available to you in the state, and we're specifically going to mention it in the context of source of income discrimination. So we'll have more on that later. Next slide, please. So what do we do? So housing civil rights laws typically identify who is protected. They determine the responsibilities of all involved parties. They determine the scope of regulatory protection and authorize jurisdiction for specifically authorized government entities, one of which is our office, the Attorney General's office, the Civil Rights Division specifically. And we are comprised of attorneys, paralegals, mediators, and administrative professionals. We are not the same as criminal prosecutors, but our mission is to enforce civil rights laws and to protect fundamental rights. So we become involved in these situations through multiple ways. One may be a complaint from the public. One may be referrals from outside organizations. Sometimes we'll see things in the press. And sometimes our own staff will do research and find out some of the issues, the civil rights issues that our residents of the Commonwealth are experiencing. And when we do get involved, we have several functions, but some of which are mediation, investigation, sometimes litigation, policy, and even appellate advocacy. Thank you. Next slide. And so what are anti-discrimination laws? There's state and federal laws that essentially prohibit discrimination in the sale, rental, and financing of housing, and in mostly any other housing related transactions. And the source of these civil rights, anti-discrimination civil rights law come from the Federal Civil Rights Act and Massachusetts' own civil rights law, which was passed a couple decades before the federal law came about. And so in these cases, next slide, please. We typically see 2 kinds of cases in this context, one of which is disparate treatment, and the other is disparate impact. So with respect to disparate treatment, the intention to discriminate must be shown. Disparate impact, however, can be shown when a policy or practice on its face, as it looks, is not discriminatory, but it has discriminatory effect in practice and application. So for example, we do know that criminal background check practices in employment, education, and housing disparately impact Black and Latinx communities because of issues involving over-policing and mass incarceration. Next slide, please. And so who are the protected classes? So it's unlawful to discriminate based on a person's race, color, national origin, ancestry, gender, marital status, religion, age, sexual orientation, gender identity or expression, military background, familial status, source of income, genetic information, or disability. And these categories encompass both the scope of federal law and down to local Cambridge law and protected categories. And so what we see between the state, the federal, and the municipal law is sometimes local communities are making sure that its special classes are protected in the anti-discrimination context. And I know CHRC is going to talk a little bit about that later. So who is covered and who is protected? So the laws apply to landlords, sellers, real estate agents, lenders, brokers, property managers, government officials, and local government entities, including housing authorities. And who is protected? Current or prospective buyers, renters, or borrowers. And prospective means you are inquiring about a housing opportunity. That typically creates a prospective relationship, and the person who you are communicating with on behalf of the housing is required to not discriminate based on protected categories. Next slide, please. Oh, sorry, we can go to the next slide, please, sorry. And so what are some of the most prevalent forms of housing discrimination that we see here? And I know Carolina will talk a little bit about some later, but we wanted to highlight typical forms of discrimination in the Commonwealth, including discrimination against families. We'll see this in the context of lead paint or familial status. We'll see discrimination against recipients of public assistance, for example, Section 8 or ERAP, or discrimination against persons with disabilities. And we can see that in the context of refusing to make a reasonable accommodation for someone. Next slide, please. And so there are a wide range of discriminatory practices that may violate the fair housing laws. And that includes outright refusal to rent or sell, steering, which means someone tries to influence someone's housing decision based on a protected factor such as race or religion. Having different terms and conditions for different people can be discriminatory. Even the advertisements or just the solicitation of renters can be discriminatory depending on what is said. And then refusal to provide reasonable accommodation. Again, individuals with disabilities are entitled to reasonable accommodations in housing. And then again, refusal to comply with a requirement of a Section 8 program where the landlord is obligated to either to have an inspection done or complete certain repairs. After the inspection is done and the landlord refuses to comply with Section 8 requirements. And then refusal to rent to families with young children to avoid lead paint abatement. So our laws require people who own homes, landlords, people who are leasing homes to abate any lead paint that is still remaining in the structures because we know of the harm it can do to children. So landlords can't just tell you, well, we have lead paint, so I can't. That would typically be seen as discriminatory against you and your young children. Next slide, please. And then there can also be discrimination in lending, not just renting. And so refusing to make or refinance a mortgage loan, redlining, which again is refusing to make a loan to a person because they live in an area, a certain area, having different terms and conditions on loans, the discrimination in appraisals. And in recent news, we've seen people of color reporting significant increases in appraisal values after they remove photos and other cultural indications from their home before a second appraisal. And some have reported that, in addition, they've asked someone that they trust to pose as the owner in a second appraisal and receive similar results. So things like that could be troubling. I'm sorry, Carolina, did you have a question?
I apologize.
No problem. And then any other discrimination in providing financial assistance, construction, improvements, repairs, and maintenance of dwellings. Next slide, please. And so we're going to take a closer look at source of income discrimination and some of the programs, assistance programs that we have in Massachusetts for housing. Next slide, please. So what is source of income discrimination? Essentially, Massachusetts law makes it unlawful for housing providers to discriminate against individuals or families who are receiving public assistance or housing or rental subsidies because, one, they are a recipient of such assistance or of subsidies, or two, because of any of the requirements of these public assistance or programs, as mentioned earlier in the Section 8 context. So essentially, housing providers cannot choose which lawful forms of income to accept from prospective tenants. Next slide, please. And so examples of lawful sources of income in Massachusetts, we have the three largest programs providing rental assistance vouchers are Section 8 and the Massachusetts Rental Voucher Program, and then the Alternative Housing Voucher Program. And we also have seen emergency rental assistance in the form of ERAP, of home-based or the RAF programs, and other programs administered by cities or towns are covered under source of income discrimination. Next slide, please. So again, all types of housing providers are covered here. And landlords are responsible for legal violations no matter who committed the violation. So if it's someone in the front office who, after you mentioned, the Section 8 form that you need to be filled out, if they commit any discriminatory practices, then the landlords can still be liable for that conduct. Next slide, please. And so again, prohibited conduct includes treating voucher holders differently, refusing to rent, refusing to negotiate, telling someone, a voucher holder, that housing is not available after you find out that they're a voucher holder, requiring people to have a particular type of income, such as employment income, also is prohibited because, again, there are other lawful sources of income that have to be accepted. Next slide, please. And so here on this slide, and I think these slides will be provided after the presentation, but we published some emergency rental assistance advisory and some more information on source of income discrimination on mass.gov. And those may be useful resources for you all. Thank you. And finally, we wanted to mention, it can definitely be tough to prove that you have been discriminated against based on source of income. But there are certain discriminatory advertisements that we'll see that can be concerning. And so essentially, it's illegal for housing providers to place advertisements suggesting a preference for tenants without housing vouchers. And its statements may include perfect for young professionals, proof of employment income required, not Section 8 certified. Again, they have to become Section 8 certified. Must have minimum income of $65,000, or even good credit references, employment and income history needed. Those types of advertisements can be evidence of discrimination against individuals based on source of income. And we definitely encourage you to report these things. Next slide, please. And finally, we wanted to look at discrimination based on disability. Next slide, please. So again, current or prospective tenants with disabilities are entitled to reasonable accommodations or modifications of their housing situations. And the individual must need the change in order to fully use and enjoy their housing. Next slide, please. So what qualifies as a disability? A disability can be physical, mental, or emotional condition. It must cause the person to be substantially limited in a major life activity. So we see this definition is very broad. And it's pretty difficult to defend against the claim by arguing that someone was not actually disabled. And what is a reasonable accommodation in this context? Request for a reasonable accommodation is a request for an exception or change in rules, policies, practices, or services, or physical modification to the housing environment. And these accommodations must be allowed unless they pose undue burden on the housing provider. Next slide, please. And so tenants with disabilities typically undergo and are owed an interactive process with the housing provider. And so the bottom line in this interactive process, which is used to determine what is reasonable, one, the request should be made in a timely manner. Two, the person with the disability need only provide enough information so that the need for request is understood by the housing provider. Three, housing providers cannot mandate certain forms be used. Verbal requests and letters from the person with disability or an advocate are allowed. However, written and dated requests may be preferable or best practice so that you have a record. And then finally, a healthcare provider documentation should only be requested by the housing provider when the disability or the need for reasonable accommodation is unknown or is not apparent. And again, these accommodations must be allowed unless they pose an undue burden on the housing provider. And so examples on reasonable accommodations, yes, Jarlene, that was a good point. For the RAFT program in Massachusetts, even if you are undocumented, you can apply. And we will have, I'm pretty sure we have, yes, we have links in the next slide to that program that you all can access. Thanks, Jarlene. Also, you may request transfers to first floor apartments for physical disabilities, exceptions to overnight guest policies, or installation of grab bars or wheelchair ramps for you to be able to enjoy the property in the same manner as others. And I realize I haven't mentioned how you go about reporting to our office when you feel that there is a civil rights violation. But that's because Carolina and the CHRC are going to go do a lot of discussion into that. Yes, Young, sorry. They're going to do a lot of discussion into that in the CHRC and Cambridge context, which a lot of it, again, the process is similar to ours. So I encourage you guys to go use the links that have been provided, including the AGO landlord tenant rights guide, the Know Your Rights guide for source of income discrimination, especially income and home and energy assistance program, the RAS program, the ERAT program, and then the homeowner assistance fund. And with that, I don't know if we're doing Q&As now or we'll turn it over to CHRC.
Thank you.
And Jarlene, you had one comment.
Yes, and I just wanted to mention too as well, in those links that my colleague Chanel mentioned, in the guide for the landlord and tenant rights, there are a section on the security deposit. We did not have provided the slides, but in that guide has the information, especially there a few times in the future, they have questions about how many times you have to pay a security deposit. It's only one time. And the security deposit cannot exceed what you're supposed to be paying monthly in the rent. So if your rent is $1,500, the one-time payment has to be $1,500 or less, and the landlord has to provide you with the account number of where the security deposit and information it is located. All that information has to be provided for you, and all that information is in our wonderful guide that our office created as well.
Thank you.
Thank you so much. I think before we switch to Carolina's portion of the presentation, we will go through a few of the questions and answers that have come in so far through the Q&A function. So just a couple things I want to recap to start. This presentation, both the PowerPoint slides from both portions of the presentation today will be shared with all the attendees who registered for the panel. So you will receive a copy of the slides. Additionally, the video of today's session will be made available on the city's YouTube channel, as well as through, and one way you can access that is through the webpage for the Office of the Housing Liaison. And I believe Carolina is going to share that link to the Office of the Housing Liaison's page at the end of her portion of the presentation. But again, we will send out these slides, which have the additional information about the ways to access this information after today's session. A couple of questions that have come in, and I will relay these questions very generally, and then I'm going to let Yarlinis answer this first one that I'm going to relay generally so that everybody can hear that question and answer that came in through the Q&A feature on Zoom. If you asked a question that is very specific to your personal circumstances, we're going to follow up with you separately, but not get into the details here, because in some ways the answer could be legal advice, and that's not a position that, as the Attorney General's staff said, not something they can do and not something we can do through the Human Rights Commission either, but we can make sure that you're getting the follow-up information and referrals to talk to legal service providers that can give you more direct guidance. So one of the first questions that came in was, when a tenant pays their rent to a landlord, does the landlord have the right to not provide a receipt for having received the rental payment? Then going through some examples of a particular person's situations where they had been receiving a receipt and then a receipt was denied. And they're trying to figure out what right a tenant has to receive that receipt. And Yarlinis, I think you had answered this. If you want to share the answer as well with everyone.
Absolutely. Thank you so much, Jennifer. My answer to that question was to please make sure if you haven't received the answer you needed from the managing company, to call our office immediately for any assistance. But usually when you do pay in cash or money order, that landlord has to provide you with a receipt. So you do have your rights. And if you feel that it will violate it or if you need a resolution, we do offer also a mediation program in our office through our Consumer Advocacy and Response Division. So if you need our help resolving an issue like this, you can call our office at 617-727-8400. Our hotlines are available every day, Monday to Friday from 10 a.m. to 4 p.m.
A follow-up question there was if payment is made by personal check, if it changes any of that advice.
Yeah, no, any type of payments that you make, you are entitled to a receipt. And Chanel, I don't know if you have anything to add, but I do advise, even if you pay in cash, money order, or personal check, you have your rights to get your receipt for that payment. Great question.
I agree. Yeah, I agree. And perhaps, you should insist on a receipt at the time of exchange, as opposed to, I know some of us mail in our rental payments. But the best you can also do if you're paying with a money order or a check or something along those lines is to retain some kind of copy as proof of payment.
And then another general question that came in is, what is the difference between a lease and an occupancy agreement?
I'm not sure. So what I will say is that just because it's named an occupancy agreement doesn't mean it's not still a lease. Leases are any types of agreements for housing, essentially. And so if you have any questions or you have any issues, or you feel like your rights have been violated, even under your occupancy agreement, I definitely encourage you to get in contact with us so you can kind of learn more about what your rights may be in that circumstance.
Absolutely. And usually, with the lease, it's that written documentation, as my colleague Chanel mentioned. And it's in that agreement, if the month or year of that rent will stay the same for what you have to pay monthly in that rent. Now, it is important for you to know, and we do advise any type of agreement, even if you're subletting or if you have a verbal agreement lease that is not it's not a written documentation, it's something verbal that you have agreed to pay for 3 months or so. It is important for you to know that anything that you have to sign, make sure you understand it completely. If you do need the assistance, call our office so we can give you some referral to resources, or reach out to the Human Rights Commission for any other type of resources that you need. But please never feel any pressure to sign any documentations you don't understand that later on can compromise you as a future tenant.
Yes. And if you don't mind, Crystal, I think our last slide had the contact information for the office. If you can share that so that individuals can take that down. And again, these will be provided after. And I know we promised you a picture of the Attorney General. And so if you go to the slide after that, you will get your picture of Attorney General Maura Healey. Uh-oh, I don't see it. Maybe not.
Sorry, I don't see a picture in your slideshow.
Yeah, sorry, that's my bad. I thought we had it. But yeah, let's continue with the questions.
And it's very important if you want to know where our offices are located to go physically. We are right in Boston, near the State House, 1 Ashburton Place. That's the most nearest to you. But you can easily call us at 617-727-8400. I just want you to know that we also utilize the language access line. If you know somebody that speaks another language, we have that capacity to serve everyone, because language accessibility is a priority in our office as well. And our complaints are translated in other languages too.
Yes.
So just two other, I think, general questions that have come in. And again, if we're not answering your specific question at this point, please know we will follow up with you with additional resources, just separately where the questions are very specific. One question is, what happens if someone has reached out to the Attorney General's office before knowing, I think the question is, before contacting the Cambridge Human Rights Commission, not knowing that there's that kind of shared jurisdiction. So the Cambridge Human Rights Commission can investigate any complaint of discrimination in housing that happened in Cambridge, where the Attorney General's office obviously has that statewide jurisdiction. However, if we want to just, Carolina and Chanel, if you can answer a little bit about if you started a process in one place or kind of how they work together.
Carolina, if you had a comment on that, I'm actually not sure about how the jurisdiction works there.
Yeah, sure. And I'll get into this more in my portion of the presentation. But generally, if you've already filed a complaint with us, it would stay with us. We do have similar jurisdiction to the Attorney General's office. But if the discrimination happened in the city of Cambridge, we're the more appropriate agency to investigate that complaint. Of course, if it happened outside of Cambridge, the AG's office or the MCAD, which I'll talk about later, would be a more appropriate venue to file that complaint. And if you had gone to the Attorney General's first, we are in communication with each other. Sometimes cases do get transferred from one office to another, or it would stay at the Attorney General's office.
Thank you.
I want to do a time check. We have about 30 minutes for Carolina's presentation. So if we can do the rest of the Q&A later, that'd be great.
Yes, thank you. And again, we'll follow up separately on some of these questions through the chat. Thanks.
Yes.
All right. Thank you so much. Welcome everyone again to the Housed in Cambridge Fair Housing Panel. I want to say a big thank you to Yarlenis and Chanel for that informative presentation regarding state enforcement of housing and fair housing rights. Once again, my name is Carolina Almonte. I am the attorney investigator for the Cambridge Human Rights Commission, and I want to thank you all for being here. Before I get started, I just want to reiterate what Jennifer said, in that we at the Commission cannot provide legal advice, so nothing in today's presentation should be considered legal advice. If you do need to consult a lawyer, we're happy to provide a contact to legal services or other referrals that may be appropriate for your situation. So please do not share personal details or other identifying specific information when asking a question. Thank you. So first, I'll start with explaining what we do at the Cambridge Human Rights Commission. So we are a city law enforcement agency. We're located at 51 Inman Street on the second floor in Cambridge. And we're an agency that receives and investigates complaints of discrimination that occur in Cambridge. And that's in housing. We also cover employment cases, education, and public accommodations. Our role is to enforce two ordinances. So we enforce the Human Rights Ordinance, where employment and public accommodations and education falls, and our Fair Housing Ordinance. These ordinances prohibit discrimination based on protected categories, which we will discuss later on. So I'll start by going through our jurisdiction, which I talked a little bit about. To make sure I am clear with what jurisdiction means, it is the authority granted by our ordinance to give us the ability to investigate and rule on legal matters according to the subject matter of the case and also the geographical region in which the issue took place. So at the Commission, we can accept cases if the discrimination occurred in the city of Cambridge. To be clear, that means that the complainant can live outside of the city of Cambridge, but the respondent business, institution, housing provider, or individual alleged to have discriminated must reside in Cambridge. The alleged discrimination must also have occurred within the past 180 days, which is about 6 months. There is an exception if the conduct first occurred prior to that 180 days, but it is still ongoing. Also, the alleged discrimination must have been based on the complainant's membership in a protected class. The last thing I'll note about our jurisdiction is that we cannot accept complaints against other City of Cambridge agencies. Those may be filed at the Mass Commission Against Discrimination. So as I said, our role is to investigate complaints of discrimination in housing, employment, public accommodations, and education. Please keep in mind that we act as a neutral investigative agency, which means that we do not represent either party. So we don't represent the complainant or the person who is filing a complaint with us, or any respondents, or the person or entities that the complaint is filed against. There is no cost to file a complaint with us. You also do not need to be represented by an attorney. However, you can obtain an attorney to represent you if desired at your own cost. Our process begins with an interview and a complaint draft, which I would draft if you're not represented. Then a copy of your complaint is served on the respondent or the respondents. After that, our process is to occasionally interview witnesses, review documents, and research applicable case law. With a lot of our cases, we endeavor to mediate or settle any disputes, which could happen at any point of the process. If mediation or settlement is successful, we would draft a settlement agreement and then the matter would be closed. If mediation is not successful, please keep in mind that mediation is both voluntary and confidential, separate from the investigative process. We would draft an agreement if it is successful and the matter is closed. If it's not successful, then we would move forward with the investigation until we reach a point of either a probable cause determination that discrimination occurred or a lack of probable cause determination. The other thing I'll add is that the CHRC is substantially equivalent to the Federal Fair Housing Act. So HUD authorizes us to investigate federal discrimination complaints. Lastly, I want to make it clear that our process is not adversarial. Our goal is not necessarily to punish respondents, but rather eliminate violations of our ordinance. So now I'll talk a little bit more about the protected categories. Chanel did a great job in going through the protected categories at the state and federal level. For us, as you notice, there's a lot of overlap with the protected categories and a lot of similarities. On this slide, the bolded protected categories are not protected under the Federal Fair Housing Act. But all of them are protected under our City of Cambridge ordinance. A few things to note is that both majority and minority traits are protected. For example, men are protected from sex discrimination as well as women. You can also be discriminated if you're a member of a group, perceived to be a member of a group, or associated with a member of one of these groups. Quickly, I'll go through these protected categories just to give some examples that may be helpful. So active military personnel or veterans are protected. Some examples would be being denied a housing opportunity or charging higher security deposits for a veteran. Age is anyone aged 18 years or older. Disability, as Chanel describes, can be physical or mental. Gender identity are folks who are transgender or in any way gender nonconforming are also protected. Sexual orientation can be gay, straight, bisexual, pansexual. Marital status and familial status is living with someone married or not. Often when it comes to familial or family status, as we describe it in our ordinance, that comes up a lot with lead paint. homes must be deletted for children under 6 years old. Ancestry and national origin are similar. The difference is that national origin is where you are from, whereas ancestry is your family background, and both are protected. Public assistance or source of income means that you cannot discriminate based on how you receive your income. So Section 8, Social Security, rental assistance programs, etc. Race and color are also similar, but color is very literal. It could be just how much melanin you have in your skin, and oftentimes how other people identify us. And race is how we identify. Religion pertains to any religious beliefs, even ones that are not common are protected. You can't discriminate against a religion you've heard of or a religion that you haven't heard of, or if you're an atheist. Sex means that you cannot discriminate based on sex or gender. This also includes sexual harassment in the housing environment, which I'll talk about later on. And lastly, this is not a protected category, but I want to make clear that our ordinance does protect against retaliation. So if someone opposes discrimination and then an adverse action is taken, that's a problem. For example, a tenant requests an accommodation, and then shortly after, she is threatened with eviction or her lease is not renewed. So who is protected by our ordinance? Our ordinance protects any applicants for public housing, or it could be rental apartments, it could be shelters or commercial spaces, any tenants in apartments or homes, in public housing, in shelters or commercial spaces, any potential home buyers in the city of Cambridge or commercial space buyers. Also, any complainant or others who speak out against discriminatory practices. That ties into the retaliation piece I just talked about, credit seekers and credit and mortgage seekers. In terms of which housing providers are covered, that would cover any owner of property in Cambridge, any landlords and their employees, which is important to note, any real estate agents that a landlord may hire to assist with renting out their properties or any agencies, any apartment managers, any management companies. We look at banks, mortgage companies, appraisers, any homeowners insurance companies, and also public housing authorities. So keep in mind that our ordinance does cover public housing authorities. It is important to note that there is an exemption when we look at two-family owner-occupied homes. An exception means that our ordinance generally does not apply. We call this the Mrs. Murphy exception, which provides that if a dwelling has two rental units and the owner lives in one of those units, that home is exempt from some portions of the Cambridge Fair Housing Ordinance. We call it Miss Murphy because it's supposed to be a hypothetical elderly widow who has converted a portion of her home into a rental apartment to supplement her limited income. However, this exemption does not apply to rental advertising. So that means that Mrs. Murphy cannot run a discriminatory advertisement indicating, for example, that a certain religious group is not welcome to rent her apartment or room. Also, this exemption does not apply when a real estate agent is representing the property owner, as the law presumes that agents are professionally trained and aware that housing discrimination is against the law. Lastly, I just want to stress that HUD takes the position that the Civil Rights Act of 1866 makes it illegal to discriminate based on race. Therefore, there is no exemption when a fair housing violation is based on race discrimination. Right, next I'll get into some common forms of housing discrimination, primarily that we see at the Human Rights Commission. So there are 4 types of discrimination, 4 or 5 that typically are filed with our commission. So the first is disparate treatment. Once again, going through that, it's otherwise known as discriminatory intent. And then disparate impact, otherwise known as discriminatory effects. So once again, that's when a policy or procedural that is neutral ends up having a discriminatory effect. The other types of complaints we often see are harassment-based, which is any conduct that is unwanted or offensive and related to a protected group. It could also be sexual or non-sexual. Then we have accommodations related to disability. So that's any change or adjustment made on behalf of a tenant, the housing environment, or the ways things usually are done that will allow an individual with a disability to be awarded the same opportunities to reside in their given home comfortably. And lastly, once again, retaliation. So fair housing laws define retaliation as unlawful coercion, intimidation, threats, or interference with anyone who exercises or enjoys fair housing rights. So an example could be a landlord issues a 20-day termination notice to a resident because she complained about a maintenance staff making inappropriate remarks or comments to her. So one of the most common discrimination claims that we see are allegations of disability discrimination. So I'll just quickly go through the definition. So once again, a disability can be either a physical or a mental impairment, which substantially limits one or more major life activities. So based on this definition, a broken arm that heals normally would not be considered a disability. Additionally, they must have a record of such impairments, or they are perceived as having an impairment. A perceived disability does not give rise to accommodation requirements, but it can be the basis for a disability claim. Remember, disabilities also do not need to be visible. When determining if a disability is a substantial limitation, we often look at the nature and severity, the duration or expected duration, and whether it's permanent or the long-term impact or expected impact. So on this slide, we just provided some examples of major life activities. As you can see, that could be caring for oneself, walking, seeing, standing, thinking, breathing, speaking. There's also more to these. These are just some examples. There are some exclusions that apply regarding who counts as the individual with a disability. So these would include individuals with substance use disorders who are actively using substances. Recovering addicts could be considered people with disabilities in housing. Another exclusion would be personality traits such as irritability, unless it's disability related. And lastly, any sort of uncomplicated pregnancy. That would be another exclusion. So what can you ask for as a tenant with a disability? Again, I'll just go over the accommodation and modifications. So first is an accommodation. So that's a change to policy or practice that is necessary for a person with disabilities to utilize and enjoy a dwelling to the same extent as a person without a disability. So we often see the no pets policy exception or providing a reserved parking space, maybe closer to the front door of a building. A modification is different because that's a request for a structural change to the existing premises that is necessary for a person to fully utilize and enjoy a dwelling to the same extent as a person without a disability. So we often see, building a wheelchair access ramp, or sometimes lowering cabinets or counters, or altering walkways to provide access to a common area in a big apartment complex. So once a housing provider is on notice for a need of accommodation, they should initiate an informal interactive process with the tenant. So what this process should do is identify potential reasonable accommodations to address the tenant's particular limitations. It is appropriate for a landlord to ask for a doctor's note, but keep in mind that it could be from any medical provider, including a therapist, a social worker, psychologist, anything like that. And keep in mind also that a reasonable accommodation just has to work. So not all the bells and whistles are required. There's also no requirement that a request for an accommodation be in writing. Housing providers do not need to provide disability accommodations if the accommodation is not related to a disability. For example, if a tenant requests unlimited guest parking for friends and family, that request may not necessarily be related. Housing providers also do not need to provide accommodations that would be an undue hardship. An undue hardship is defined as an action requiring significant difficulty or expense, when considered in light of a number of factors. So these factors would include, for example, the nature and the cost of the accommodation in relation to the size, the resources, and the structure of the housing provider's operation. One example of an undue hardship would be, building an elevator in a 3-decker in Cambridge that maybe was built in the 1900s. But this is determined by a case-by-case basis. And lastly, a request would be unreasonable if it would fundamentally alter the nature of a program. So that means that it will alter the essential nature of the goods and services offered by a housing provider. So next, we'll jump into our second most common discrimination claims that we see at the Human Rights Commission, which is discriminatory harassment. So what's the line? When someone makes a discriminatory harassment claim at the Human Rights Commission, we often look at 3 things. The first is, was the harassment unwelcome? Was it severe, or pervasive? Keep in mind that harassment does not need to be both severe or pervasive to satisfy this requirement. One single discriminatory action can satisfy the requirement if it is severe enough. And finally, the harassment needs to be related to a protected group. So now we'll talk a little bit more about a specific type of discriminatory harassment, which is a hostile environment in housing. So a hostile environment can be created if verbal or physical conduct is so severe or pervasive that it interferes with the individual's use or enjoyment of his or her home or their home by creating an intimidating, hostile, or offensive environment based on their membership in a protected class. So harassing conduct includes coercing a person to deny or limit their benefits in connection with the sale or rental of a dwelling, or in connection with the residential real estate related transaction because of a protected class. So an example could be that a staff person tells a negative joke about an Asian person in front of their manager who does nothing about it. Harassing conduct also includes threatening, intimidating, or interfering with someone's enjoyment of a dwelling because of their protected class or that of their visitors or associates. So an example of that would be a landlord warns a resident that he would be evicted if he continues to have visitors who are Black. Another form of discriminatory harassment is sexual harassment. Sexual harassment in housing is a form of sex discrimination, and there are generally 2 main types of sexual harassment. The first is quid pro quo, which occurs when a housing provider requires a person to submit to unwelcome requests to engage in sexual conduct as a condition to obtaining or maintaining housing. For example, a landlord tells an applicant that he will not rent to her unless she has sex with him. Or a property manager evicts a tenant after she refuses to perform sexual acts. A hostile environment, apologize about that. A hostile environment harassment occurs when a housing provider subjects a person to severe or pervasive unwelcome sexual conduct that interferes with the sale, rental, availability, or terms and conditions or privileges of housing or housing-related services, including financing. So some examples of that would be a maintenance worker making inappropriate sexual comments to a tenant, or a property manager making severe, pervasive, unwelcome lewd comments about a tenant's body. And as I mentioned before, our retaliation is covered by our ordinance. So what is retaliation? It means that it is illegal to retaliate against a person for making a complaint, for testifying, for assisting with our complaint process, for participating in any manner in a proceeding under a complaint process at any time, even after the investigation has been completed. It is also illegal to retaliate against any person because that person reported a discriminatory practice to a housing provider or other authority. So if you believe that you have experienced retaliation, you can file a complaint with us. Some examples of retaliation would be a resident complaining to their manager or landlord that, and then that they received a 10-day notice to quit because of their race. The manager then gets angry and gives her an eviction notice. Another example would be a resident who was a witness to a complaint investigation and someone who I ended up speaking to then gets told by their manager that he is keeping an eye on her. And these are just examples of additional forms of discrimination. A few things to note, once again, is that housing authorities are also landlords. Landlords can be big or small. They could have one property or they could have 10 properties in Cambridge. So some other forms that we would look at would be inquiring about membership in a protected category, refusing or delaying to rent, negotiate, sell, discriminatory terms and conditions, misrepresenting availability of housing, altering the terms or conditions of housing, steering, which Chanel described, discriminatory lending, discriminatory advertising, and use of intimidation or coercion. We also wanted to take a moment to talk about the continuing impacts of COVID-19. As we are all aware, COVID-19 has had a disparate impact on people of color and those in other protected classes. Additionally, Cambridge residents who rely on public assistance, including our various rental assistance programs, often face unique challenges in securing and maintaining housing. Once again, we want to stress that landlords cannot discriminate against individuals because of the source of income. So that could be derived from employment, or it can be derived from other public benefits such as Section 8, such as veterans benefits, Social Security benefits, the RAFT program, etc. Lastly, as we know, misconceptions about the origins of COVID-19 have fueled discrimination against Asian Americans. We want to stress that it is illegal to harass, terminate a lease, refuse to rent, or retaliate against anyone based on their race, color, or national origin. So this is our information in terms of how to contact us at the Human Rights Commission. To file a complaint with us, you may call that number that you see on the screen, which is 617-349-4396. You're welcome to send an email to our HRC mailbox, which is hrc@cambridgema.gov. For more information, you can visit our website. And we also accept walk-ins. So we're in the office. You can come in and meet with us if you have that as a preference as well.
Thank you so much, Carolina. We have just a couple other general questions that came in through the Q&A. One of the questions was whether, as we've said a few times, you can report to the Attorney General's office or to the Cambridge Human Rights Commission. And the question was whether there are any drop-in restrictions for making claims at this point. So for the city of Cambridge, there are no drop-in restrictions, related to COVID, if there are any restrictions. So for the city of Cambridge, we can answer there are no restrictions at this point. Our city offices are open during regular business hours, and you can certainly come by physically to make a complaint or talk to our staff if that is easier for you. I am not positive about the Attorney General's office, if you all could clarify.
Absolutely, Jennifer. So for our office, all visitors have to wear masks.
Thank you. And then another question that had come in is if you could talk a little bit more about reasonable accommodation and how an individual's request for a reasonable accommodation is determined. Is there, are there general accommodations that are always seen as reasonable? Does it need to be more specifically tied to the individual and that individual's needs?
Sure, I'm happy to answer that question. So the accommodation does have to be closely tied with that individual's request. There aren't, there's a lot of common reasonable accommodations that we see, such as, exception to no pets policy, or with guests staying, if you have a personal care attendant staying with you, or, moving your parking space closer to the front door. But regarding any reasonable accommodation request, the reason why there is that interactive process is for a landlord to work closely with you to try to figure out the best way to help with specifically what you're looking for. So that's why it's required for landlords to engage in that process.
Another question was for a little more information about what housing payment related programs can what the funding can be used for. For example, Section 8 housing voucher or other public funding. For example, could housing payments be used to help with after school tuition?
That's a good question. I'm not sure of the answer. My understanding is that generally those, when it comes to RAFT, for example, or those kind of organizations, they help with any back rent that you may owe so that you can sustain your housing. And then Section 8 payments are used to cover a portion of your rent. It's a calculation that a housing authority would do with you to determine generally that you pay 30% of whatever your income is. So I don't know if it could be used for anything not specifically related to your housing. I don't know if anyone else has anything else to add.
Yeah, correct, Carolina, from what I know. And even with RAFT, the payment will go directly to the landlord, not the tenant. The ARAP, there are some situations where, if the landlord is unresponsive and they have stated that they won't participate in that program, then the money will go directly to the tenant to pay the rental owed rent. But I know a lot of cities and towns might have some designated money to help their residents. So I would urge you to call your cities and town office to see what type of other resources they might be available for you. Maybe like the Human Services Department could help with that.
Another question that has come in is, can a landlord refuse to rent to a tenant with a Section 8 voucher? That's kind of a broad question. So I think if we could talk a little bit about it, whether you can refuse to rent to someone because they have a Section 8 voucher, and then what other reasons that people with a Section 8 voucher may not get housing, but that might not be discriminatory are. I think it's kind of two separate pieces.
Sure, so I'm happy to answer that question. So a landlord cannot, that's the best way to answer this. So it is lawful for a landlord to have a tenant screening process that is evenly applied. So if they have a process where they review applicants neutrally, no matter if they have a voucher or not, that is fine. So they can do, a credit pull, they could look at landlord references, but they can't treat Section 8 holders differently in that they only, look at like the criminal history of someone with Section 8 or things like that. So they can't just say that they don't want to rent to someone with Section 8 due to the inspection requirements through the Section 8 program, or because, they have different, misconceptions of Section 8 holders. That would be a violation of our ordinance.
If I could just add, what Carolina said is exactly right. And perhaps you don't have direct evidence of being denied because you're a Section 8 voucher holder, but there are certain events that may happen in the process that may be some indication, and that includes you requesting that they complete the required forms, Section 8 forms, and like Carolina said, undergo the appropriate inspections and repairs. If they suddenly stop communicating with you or say that, the housing is no longer available, or somehow deny you, the ability to move forward in the process, then you may have an incident of some kind of source of income discrimination. But we all know that housing issues do not come alone. And so they may look at other areas of your life, such as your credit and rental history, in determining whether to accept or deny your application. So it's tricky, but the simple answer is they cannot deny you housing because you have a Section 8 voucher.
And one more general question that's come up during rehab, and I think this means rehab of buildings. So if you're doing construction or some sort of changes within a building, there are often a lot of nuisances that go with that. So who can someone contact if the work going on and the nuisances around it become overwhelming to the point that they interfere with quality of life, they're limiting reasonable access to elevators or to the building?
I would say, Jennifer, to get a little bit about the cases, because each cases are very differently, I would advise to call our office, our consumer hotline number, which is the 617-727-8400, and to talk to one of our consumer specialists, because even if we cannot help, we can still refer you to the right agency that can help you with that issue.
Thank you so much to everyone who joined us today. I don't see any more questions coming in at this point, so we're going to go ahead and wrap up. Thank you so much to Yarlinis and Chanel from the Attorney General's office for presenting with us today. Thank you to Carolina for her presentation. And thank you all for participating in another Housing Cambridge panel. Again, this information will be shared, and we thank you so much and look forward to having you at the next Housing Cambridge panel.